Okay, we are being recorded.
Yep.
So let me get up on the screen where we're up to. We are still on 9b, and we are on the 8th and final explanation of our case of the Mutzi Shem Ra, the defamer, and we got halfway through the 8th case last time when we ran out of time. So we're going to finish the 8th case today, and then we'll see where we go from there. So let's get the Gemarah up. Those of you who are following in the Steinsaltz hard copy, it's on page 47, and it should be up on the screen for you there. So here we go. Let's just do what we did last week, this little line, because it leads into the bit we didn't do. So remember, our case is a discussion between the rabbis and Rabbi Meir. Rabbi Meir is the one who says we only need 3 judges for the case of the defamer because it's always going to be a monetary case. Only the sages, the Chachamim, are the ones that say, no, we need 23 judges, because it could turn into a capital case. And then we've had 8 different explanations of why and in what particular circumstances Rabbi Meir and the sages may differ. So this is the 8th one, the Ibai Tema. And if you want to say, this is another example of what it might be. Kagon de itkachush bibdikot velo itkachush bachakirot. We did this last week. And I'm sure that those of you who said Rabbi Yishmael Omer since last week have said it with more understanding than you did before, having found this word itkachush. So there were contradictions in the examination of the witness, but there were no contradictions in the interrogation. And if you remember, last week we went through what was what. The Chakirah was the basic information about where and when the alleged crime took place, because unless you can say where and when the crime took place, your evidence is not capable of being dismissed by hazama, by somebody else coming along and saying, oh no, you weren't there at that time. Because unless you can say where it took place and at what time it took place, nobody can contradict you. So evidence of this nature must include the time and the place of the alleged crime. Now, if there are contradictions in the Chakirah, in those basic details of time and place, which is called Chakirah, interrogation, if there are contradictions between the 2 witnesses there, it's ois, forget it. The whole evidence falls apart, because that is basic. However, in our very specific case, sorry about that. In our specific case, there is no contradiction in the Chakirah. There is no contradiction in the time and place, but there is contradiction in some other details, and we're going to go and see what that is now. Yes, Julia, you have to unmute.
I find it a bit difficult to understand how they can be so precise about times and dates when presumably nobody had watches or clocks or calendars. And I know that they knew when the Yom Tovim were and when Shabbat was, but I still can't quite get my head around them being able to be very precise.
Okay, well, that's a fair comment. In terms of the day, they could be very precise because they knew when Rosh Chodesh was, because that was announced. That was announced every month. They knew when Rosh Chodesh was. They also knew when Shabbat was, because every day we say Hayom Yom Rishon, Hayom Yom Sheni, Hayom Yom Shlishi. So they knew what day of the week it was, and they knew the day of the month. and they knew what month it was, because every month at Rosh Chodesh was declared. They knew it better than we did, because if I was to ask a bunch of people what month it was, in the Hebrew calendar at least, quite a lot of them wouldn't know. But they did know, because it was announced, and their lives revolved around those days. So I don't think the day is a major issue. I take your point about the exact time. They didn't have watches. However, they did, and they were very aware of the times of day of things, because there were various things that had to be done at various times. If you were in an agricultural society, then you had to do your various jobs of milking the cows and all that kind of stuff at certain times. And they would know from much better than we would, from looking at the sun, what sort of time it was. So I take the point. And if you were saying, well, you know, no, it wasn't 2 o'clock, it was 10 past 2, then I think you're right. But I'm not sure that what they're saying is, was it 10 past 2 or was it 2 o'clock? I think it's, you know, it was the morning of or the afternoon of, and I think it's probably at that sort of level. And so, and I think that's where the chakira comes in.
They must have knew what time. They must have knew what time they were davening, Johnny.
Yes, they knew. They also knew various times, and they went from sunrise, dawn, sunrise, and then they watched the sun. So it's a fair point, and I don't think they needed to be super exact, but you get the point. That they
the sundials were very, very accurate. I mean, they're quite accurate, the sundials.
Yeah, I think that's right. But I think the point that Julie's making is that not everybody has a sundial on their wrist.
No.
Johnny.
Yeah.
Johnny, in answer to Julia's question, we'll get in a few years' time to a Mishnah in Sanhedrin in chapter 5, which deals with this specific question about time periods that can be accepted in evidence. And then the maximum discrepancy that's allowed is 2 hours.
Okay, there you go. Thank you for that, David. It's very good to know what's coming up in a few years' time. Okay, good. Okay, so that's chakira. So in our case, chakira is clear. We've got no contradiction between the witnesses, but we do have contradiction in other testimony. Now, what we're going to do now is have a look at a Mishnah in 40a, which we will get to in a few years' time as well. And there is a discussion here, and we spoke about this very briefly last week, Ben Zakkai, which is Yochanan Ben Zakkai, and the Rabbanan. So, v'kamiflika beklukta de Ben Zakkai v'Rabbanan. Our case here of Rabbi Meir and the sages parallels the discussion, the disagreement between Ben Zakkai, Rabbi Yochanan Ben Zakkai, and the sages. Ditnan, we've learnt in the Mishnah. And I don't need to take you to the Mishnah on 40a because it tells you here, quotes it for you. Maaseh ubadak ben Zakkai b'uktzei te'enim. So, Rabbi Yochanan ben Zakkai was a judge at this particular time, in this particular case, and it was a capital case, and he examined the witnesses on the following point. The witnesses were examined on how thick the branches of the fig tree under which the alleged crime took place were. So he said to the witnesses, how thick were they? And one witness said they were very thin, and another witness said, no, they were thick. Okay, so nothing, of course, to do with the crime itself, nothing to do with the time and place of the crime. However, this is Rabbi Yochanan ben Zakkai trying to establish whether their evidence is credible. Because if they can't tell us this detail, well, the possibilities are that they're not very observant about the fig tree, because they weren't looking at it, because they were looking at the crime. And in our particular case, they were looking at a crime of people committing adultery. Not surprising they couldn't remember how thick the tree was. Or you could say, well, maybe they weren't there. If they didn't know that detail, maybe they weren't there. So this was an itkachush. It was a contradiction in the testimony of a bedika. And he, in this case, Rabbi Yochanan ben Zakkai, when he found this discrepancy between the witnesses on this particular point of how thick the branches of the fig tree were, he dismissed the case and said, your evidence is unreliable. Now, let's see if we can work out what that's got to do with our case. So, if you want to look without thinking, it tells you in the Steinsaltz. But if you want to think it through for yourself, don't read the Steinsaltz here. And let's see if we can work it out. Rabbi Yochanan ben Zakkai dismissed this evidence. So, if we're talking about parallels, which one of our protagonists, Rabbi Meir or the sages, are likely to go along with Rabbi Yochanan ben Zakkai? Is Rabbi Meir going to go with him, or is the sages going to go with him? Leon?
Well, it depends at what stage they disagree. If they're disagreeing when the judge is talking to them before the hearing, then maybe there's no significant difference between the two witnesses. But if they come to court and then start disagreeing, then I would think that the disagreement might prevent them from being valid, credible witnesses.
And therefore?
Therefore, the case would be dismissed.
It would be dismissed as a capital case, yes. And therefore?
And therefore, it would be Rabbi Meir who thought that this was good support, because
yes.
Because it's never going to be a capital case where you need 23 judges.
Correct. Absolutely correct. So Rabbi Meir will be the one who goes along with Rabbi Yochanan ben Zakkai, because he will say, in our case over here, where there is a disagreement in the Bedika, he will say, like Rabbi Yochanan ben Zakkai, there's a disagreement in the evidence here. In other words, your evidence, as you said, Leon, is not reliable. And in that case, if it's not reliable, it's not going to be a capital case, because we can't have a capital case based on unreliable witnesses. It's never going to be a capital case. And so 3 judges are sufficient. That's Rabbi Meir's view. The sages, the Chachamim, will go along with the other opinion. We're not told what the other opinion is here, but obviously the other opinion is the opposite of what Rabbi Yochanan ben Zakkai says, which is that it doesn't matter if these 2 witnesses don't know or contradict one another about the thickness of the branches of the fig tree, because it's such an insignificant and irrelevant detail that you can't expect those witnesses to know the ins and outs of the local fig tree, because they weren't taking notice of it. That means if we're not going to dismiss their evidence on the basis of that contradiction, then it might still turn out to be a capital case, because these witnesses come along they are interrogated about time and place, and there's no contradiction. They're interrogated about a minor detail, there is a contradiction, but the Chachamim, the rabbis, dismissed that contradiction as being irrelevant, and therefore their testimony could still be valid, and therefore it could be a capital case, and therefore if it could be a capital case, then you're going to need 23 judges, and that is the Chachamim's version of events. Okay, just give me a second while I just reply to this person who keeps ringing me, and tell him 1 second. Right, okay, fine. Let's go back to the screen. Okay, can you see the screen again? Yeah, okay. So that's our case. That was the 8th case. Now, we can see that little symbol there. That means we come to a new subject. But Leon, you're disqualified from this question, because I know that you've got it in front of you in the art scroll, as I have. The art scroll very kindly lists for us all 8 cases. Now, those of you who don't have an art scroll in front of you, let's see how good your memory is, and let's see how many of the 8 cases we can get between us regarding our case, because we've been doing this for quite some time, and those of you who remember the first few will be very impressive. So I don't mind which order you take them in. Let's see what we can remember of the 8 cases. Go on, Julia. You kick us off.
The only one that I think I remember at this point is that they weren't told about the punishment, or that the punishment wasn't the correct punishment.
Okay. Okay, yes, that's correct. Remember, we're talking about witnesses who had witnessed this alleged adultery, turning the monetary case of the ketubah into a capital case. And one of the cases that Rabbi Meir and the sages argued about was the case where she wasn't warned properly. When I say she wasn't warned properly, she wasn't told exactly what the punishment might be. So that's one. Okay, any others that you can remember? So that's 2 actually that Julia mentioned. One, that she was told the wrong punishment. She was told lashes instead of the death penalty, or the other way around. And the other one that Julia mentioned there was that she was told the death penalty, but she was told the wrong type of death penalty. So I'm going to give you 2 for that there, Julia.
I have another one.
Okay, anyone else? Julia?
The cover of the judges.
One, she wasn't told anything at all.
Well, if she's not told anything at all, the whole thing doesn't start, because then she's not warned. She's not warned.
The covered of the judges.
Say that again, Michael.
The covered of the judges.
The covered of the judges, yes, that was Rava, yes.
The status of the witnesses, that the witnesses were disqualified.
Well, if they're disqualified, I don't think that was one of our cases. I mean, that was part of the idea of Hazamah. We learned that as we went along, but it wasn't one of the 8 cases. Okay, so I think we've got 3 or 4 by now. Any others? Okay, let's go through them. Let's go through them quickly. I've got the advantage of having the art scroll in front of me, so and I've also got the advantage that I practiced last night, so I'm not doing it off the top of my head. Number 1 was Ulla. Remember Ulla? He was the one that said we're worried about gossip. Okay, that somebody will come along and say, oh, they're doing a case about a girl not being a virgin on a wedding night. Oh yes, I can know about that. I was a witness to that. So Ulla says we're worried about gossip. Rava says we're worried about the kavod of the judges. That was number 2. Number 3 was Abaye, who says that she was the method of execution was not specified. Number 4 was Rav Papa, who said, this was the one that I couldn't remember either. When I read it, it reminded me of it. Remember, somebody mentioned about witnesses being, the woman being warned. Remember, if she's a chavera, if she is a learned woman, there was a machloket as to whether she needs a warning, whether a chavera or a chaver needs a warning. So that was one case, that she was a chavera, and then the dispute was whether she needed a warning at all. That was, who was that? That was Rav Papa. And then we had Rav Ashi, number 5. She was told that if she committed adultery, she'll have lashes. In other words, she was told lashes instead of the death penalty. And that was number 5. And then three cases that Ravina suggested. One was that there were more than 2 witnesses, one of whom was ineligible. And then we had the idea of whether one witness passes the whole lot, makes the whole lot ineligible or not. That was one case. The second one of Ravina, which is number 7, was that the witnesses themselves did not give the warning. Somebody else gave the warning. And finally, our case is where the witnesses got some minor detail incorrect or were inconsistent between them in some minor detail. So these were 8 different possibilities as to the case on which Rabbi Meir and the Chachamim differed. The idea being, of course, that in all other cases, they would agree and wouldn't need to have this machloket. So that was a very interesting little section, because on the way, we learned lots of different halachot. We learned about the idea of hazama, of the contradictory witnesses. We learned about the idea of the witnesses needing to be the warners. We learned about who is pasul, who is disqualified from being a witness, the relatives, and those people who are considered unfit to be witnesses. So it was a very worthwhile little section of Gemarah, not just in and of itself, but because of all the tangents that we went off on. So let's now bring a different case. It's connected a bit, but it's a slightly different case. Amar Rav Yosef. We're going to develop it a little bit further now. The Gemarah discusses scenarios concerning the testimony about a woman's committing adultery and the allegations that the husband is guilty of defamation. Okay, so here we go. What happens in this case? Hevi bat haba'al, the husband brings edim, witnesses, she'zinta, that she committed adultery, from the word zanut, meaning profanity or something not nice. A zona is a prostitute. A ben zona is not a nice thing to call somebody. So this is the same word. So the husband brings witnesses that she committed adultery. And then what happens? The Hevi Ha'av, the father of the girl, brings edim, witnesses, the Hezimum le'edei Haba'al. The father brings witnesses that say, no, you were not there at that time and place because you were with us in a different place at that time. So they are, as we've discussed, Eidim Zomamim. They are contradictory witnesses who prove that the original witnesses were conspiring to cause trouble. And as we learnt previously, a few weeks ago, the punishment for witnesses who are found to be conspiring is what? What's their punishment?
The same as would be done to the defamed woman.
Correct. The same that would be done to the person that they're trying to get into trouble. That's not only in capital cases, it also works in monetary cases. So if you are conspiring witnesses to cause somebody to have a monetary loss, then you would have to pay a fine to that same value. Here we're talking about capital cases. So,
do they go straight in, excuse me, Johnny, for interrupting. Do they go straight in and accept the father's witnesses as creditable witnesses?
Well, they would be
mention of a case or anything.
They would be interrogated, and if they were considered to be worthy witnesses and not witnesses who were possul, and they went through the interrogation process, then yes, they would believe. There is a klal that witnesses that come along and say that the first witnesses were not there are believed over the first witnesses.
Yeah, right.
That's a klal in halacha.
Yeah.
So you'll say to me, well, what if a third set of witnesses come and say, well, you weren't there either? So you can't say. You said, first of all, Chaim and Yankel say, we witnessed the adultery on Monday afternoon. And Reuben and Shimon then come and say, no, on Monday afternoon, you were with us at the bowling alley, so you couldn't have seen it. And then Levi and Yehuda come along and say, no, Reuben and Shimon, you were not in the bowling alley on Monday afternoon. You were in the pub with us. So, and then, I mean, you could say, Ein sof l'davar, there's no end to this. In that sort of scenario, you get to a situation where the judges, I imagine, hold up their hands and say, this whole thing's ridiculous. None of you are reliable. And I guess the case is dismissed at that point. But in our case, where there is just one set of contradictory witnesses, the general rule is that the contradictory witnesses are believed over the primary witnesses. Yes, Julia? Oh, I thought you had a question. All right. So now then, we have a situation here. We're going to learn today a very, very important and repetitive rule, a very important rule in halakha we're going to come to shortly. And it's brought up by this question. So we have a pair of witnesses who have been found to be conspiring witnesses. They are Eidim Zomamim. And as we know, they get the punishment that they tried to cause to somebody else. So in our case, they said about this woman that she was an adulteress. The adulteress, had she been found guilty, would have suffered the death penalty. So the witnesses who are conspiring witnesses suffer the same fate. So far, so good, yeah? You're with me so far? That's something we've already learned. Now, what we haven't considered...
The witnesses before a court case should be warned that if you're not telling the truth, you're going to get misa.
Well, I guess, yes, I suppose that they should be warned that that's the case. They ought to know the halakha, that if you're Eidim Zomamim, you'll get that. But I don't know, we'd have to ask Leon, he's the judge. Leon, you would no doubt warn the witnesses that they were on the witness stand, they were under oath, and that they should be aware that they are under oath and the consequences of perjuring themselves.
Because I think in England, if the police forget to caution somebody, I'm not sure the technical thing, but they can't prosecute them. That's one of the.
Well, I think probably if they don't caution them, their evidence may not be be admissible. Yeah, I don't know.
Okay.
I doubt the situation would be as Johnny suggests. It's like the witnesses, subsequent witnesses accusing the previous witnesses in a long chain, which, as you say, the judge would throw up their hands and say, forget it, this is no good. You can't keep warning everyone all the way along the line, I don't think.
No, I think it's understood, isn't it? When you go into the witness box, you know the story. If you're aware of your responsibilities, and you're aware of the potential pitfalls.
Yes, I think.
Yeah, I mean, I've been in court on occasions where I've heard witnesses say outrageous things which are very clearly, to any normal human being, not true, and somebody in the court, either the judge or one of the counsel, has reminded the witness that they are under oath, in a rather showy sort of way, indicating that they don't believe a word of what they're saying. But it doesn't happen very often, I don't think. Okay, so we've got these Eidim Zomimim. We've got these witnesses who have been shown to be conspiring witnesses. We know that they are going to suffer the death penalty because that is what they tried to get on the woman. But there's something else, isn't there? Because if this woman was an adulteress, then she would lose the value of her ketubah. And therefore, she's not only lost her life, but her estate, at least, has lost money. So you may think that the conspiring witnesses, before they get the chop, have to pay the fine, have to pay a fine of the money that they have caused to be lost as well. Okay? So because they've caused two things, haven't they? They've caused a monetary loss, or they tried to cause a monetary loss, and they tried to cause the death penalty. It's most likely, to be honest, that what their intention was more to save the bloke money, because it doesn't really gain the guy very much if his bride is put to death. I mean, doesn't really care if he's going to divorce her. What does it make any difference to him if she's there or she's not? What makes a difference to him is whether he pays out the ketubah. So their intention may actually have nothing to do with the death penalty. Their intention may have been to save their mate a few bob on the ketubah. So the question that the Gemarah is asking now is this: are these Eidim Zomimim, are these conspiring witnesses liable for both bits of the punishment? In other words, are they liable for the death penalty because that's what they were going to cause to the woman? And are they also liable to a monetary fine because they were going to cause monetary loss to the father of the woman or the woman herself, to do with the ketubah? Okay, without looking in, who thinks that they have to do both?
I'll go with both.
You'll go with both. Okay, Michael goes with both. Anyone else with Michael? Okay, well, if I hadn't looked in, I would put my hand up, because I think it's logical that they should go with both, because why shouldn't they? That's what they were. The whole point is that you get what you tried to cause, so you should get both. Now I've spoilt it, because you now know that they don't get both. Okay, so the answer is not like Michael and I would have said. Let's read on and have a look. According to Rav Yosef, Eidei Haba'al, the witnesses of the husband, i.e. the naughty ones who conspiring to do wrong, neheragin, from hereg, are killed, they're executed. Ve'ein mishalmin mammon, they do not pay money. They do not incur, as he puts it here, they do not incur the liability. Okay? And this is based on a very, very important halachic principle, which is not brought specifically in this Gemara, the actual words, but it's very important. I tried to find a nice section where it's actually brought out, but I couldn't readily put my fingers on one to put on the screen. So I'll have to tell you what it says. And you will, if you learn Gemara at any sort of pace more than we do, you will sooner or later come across the expression kam lei midaraba minei. Kam lei midaraba minei. Okay? And if you go and sit in the Beit HaMidrash of any yeshiva, you will get to hear kam lei midaraba minei pretty quickly in every yeshiva every day, because it's such an important principle. Kam lei midaraba minei. Let's have a look at what the words mean. Kam means to arise, get up, okay, to establish, okay. So, for example, Tzor Yisrael, next word, Kuma. Tzor Yisrael, Kuma Be'ezrat Yisrael.
Yeah.
Arise, the rock of Israel, arise and help Israel. So Kuma means to arise. So Kamle, so that means it is established, it arises. Midaraba Mine. So what's Rabba? What's Rov? What's Harbe? All of those words.
Majority.
The majority, yes, more, greater. The majority is the greater of the two, right? So kam le midaraba mine. So the punishment that is established is the greater mine of them. So when you have two punishments, the person gets the punishment which is more severe, and he is let off the less severe punishment. So if there are two punishments, he only gets the one. So if you did two averas in one go, and there were two punishments for it. So for example, and the classical example is that somebody sets fire to somebody else's pile of grain on Shabbat. So if you set fire to somebody's pile of grain on a weekday, you would have to pay for the grain because you've damaged his property. If you do it on Shabbat, you don't pay anything, but you do get the death penalty, okay? Because the death penalty is worse than the monetary punishment.
In that case, surely the guy who's burnt down the hayloft or whatever, or burnt down the hay, he's actually going to lose out dramatically. He's going to lose out from the hay. He's not going to get any benefit from the guy being executed.
Yeah, that's right. He won't get his compensation. You're right. Doesn't seem fair, does it?
So they're both going to be punished effectively.
Well, what it means is that the man whose grain is burnt is not compensated by him. I suspect that there was a system whereby the community, the court, the state would, in that situation, compensate the victim in the same way as you have in the UK, the MIB, the Motor Insurers Bureau. So when you get whacked up the back end at the traffic lights by somebody who doesn't have any insurance and has no money to pay for your repairs, then the Motor Insurers Bureau picks up the tab and will pay for the damage done. So society pays up in that scenario.
I suspect that's very rare, because they said if somebody executes once in 70 years, that Sanhedrin executes one in 70 years. So it's a highly unlikely situation anyway.
Correct. That's true. It is true. And it's used, the example is used as a classic example to teach the law of kamle midoraba mine. Doesn't only apply to capital cases. So in other words, if you did something which was to give you the punishment of lashes and a monetary fine, the same thing would apply. So kamle midoraba mine, it's a very important principle in halakha, that if there are two punishments, the person only receives the more severe punishment. Okay, so that's what we have learned.
Sorry. There's a bit of confusion with criminal and civil, and we know that there's no prisons. We know that as far as criminals concerned, the punishments are death or the lashings. But the majority of the court cases that we understand that are decided are civil cases where we're talking about compensation. And therefore, I think that it's not a question of a punishment, really, if we're talking about compensation, that they're two different matters entirely.
That depends on what you call the payment that the person has to make. If you are a thief, not you, of course, if one was a thief and you were caught and you had not owned up, what is the situation? What is your sentence? I won't use the word punishment then. What does the judge say you have to do?
If you're a thief,
you steal £100, what do you have to do?
Well, if we're talking about these courts, then we're probably talking about paying it back. But if you were in a system with criminal and civil at the same time, then the judge isn't interested in paying back. You'd bring a civil claim for that, as far as I understand it.
Yeah. So in halakha here, it's all rolled up into one. So a thief who is brought before the court and he's accused of stealing £100. Reuven is accused of stealing £100 from Shimon. And he's found guilty, let's say.
But can I stop you there? Because I thought that the system that we're discussing wouldn't be a question of being found guilty, but would be being found liable.
All right, okay. He's found liable. What's he liable for?
Recompense.
Okay, recompense. And what is the recompense that he has to do? In our case, he's found liable for having stolen £100 from Shimon.
Yeah, his liability would be to repay the £100.
Yes, that's correct. But halakha tells us that a thief who is caught and found liable pays double, kefel. Now,
punitive damages, which is also within a civil system.
Okay, so you can call it punitive damages, or you can call it a fine. So it depends on the language that you use. The bottom line is that it's not just compensation, because if it was just compensation, he'd pay £100 because that's all the guy's lost. Now, if he steals a sheep or a sheep or a cow, how much does he have to pay?
The value?
4 or 5 times the value, depending on whether it's a sheep or a cow. Okay, that's the halacha. We find it in Parshat Mishpatim, if I'm not mistaken, David. Am I right?
Correct.
We find it's a case of 4 or 5. Now, why is that the case? Because it's a fine. You could call it punitive damages, or you can call it a fine. So the whole thing's rolled up into one. It's not just compensation, because why should the guy who has a cow stolen get 4 times the amount of money? Why didn't he just get the value of the cow? Why did the woman who drove off from McDonald's with a cup of coffee between her legs and spilt it and suffered burns, why did she get $3 million for that? She hadn't got anything, in my view, because she was stupid. But anyway, she got $3 million because that was punitive damages. She got $3 million because the judge awarded punitive damages against McDonald's because the coffee was too hot. Right? It's a very famous case. Look it up if you're interested. Punitive damages. We don't have punitive damages in the UK, but there you go. So, how did we get onto that? Yes. So, kam le mid'rabba minei. That is something that is well worth remembering, because as you go through your Gemarah life, by the time you've finished Shas, when you're 1,000 years old, you'll have come across kam le mid'rabba minei many times. So this is what we're discussing here. Now, what happens here? Let's go on to the next case. Chazar, the husband came back before his witnesses were executed. And it's our case that we said before. V'hevi ha'ba'al eidim v'hezimum le'edei ha'av. He brought another set of witnesses that said, no, you can't have been with my witnesses in the pub on Monday afternoon, because I've got witnesses to say that you were in the library on Monday afternoon. So we've now got this case, which is now a chain of conflicting witnesses. So then what happens? Eidei ha'av neheragin. The ones who have now been found themselves to be conspiring witnesses, they are executed, u'mishalmin mamon, but they also have to pay the money as well. They're not exempt for that, because they're against different people altogether. Okay, mamon lezeh unafashot lezeh. So the monetary case is against the first one. The capital case is against the other witnesses. So it's it's almost like 2 separate cases. So this is the opinion of Rav Yosef, that kam le mid'rabba minei only applies when there is a 2 separate cases. Let's have a look over here in the H bit of the halacha. If someone defames his wife, presenting witnesses that she committed adultery while betrothed, and then the father brings witnesses who render the husband's witnesses conspiring witnesses, the husband's witnesses are sentenced to death and are not required to pay the amount of the fine for the act of defamation. That's the first bit. Second bit, if before those witnesses are executed, the husband brings witnesses who render the father's witnesses zomamim, the father's witnesses are executed, and then they're also required to pay the husband the amount of the fine, because it's two different cases. Okay, so we've established now two important principles. Number one, kam le mid'rabba mineh, that you are only liable for the most serious punishment and not the secondary punishment. And secondly, that principle only applies when we're talking in a one case, not when we're talking about, in effect, two separate cases, one against the original litigants and then against a second set of witnesses who came along. Okay. Whilst we are on Rav Yosef, the Gemara says, oh, and by the way, I'll tell you something else that Rav Yosef says, which is interesting. Ploni reva'o la'onso, hu va'acher mitzdarfin lahargo. Okay, so now we're talking about how you get to have two witnesses, who can join together to be two witnesses. Let's have a look at what the note says, because it explains it very nicely. If one person testifies that somebody else, another person, sodomized him, in other words, did something which is not allowed, al pi halacha, sodomy is a capital offense. Even if the one who was sodomized testifies that he consented to the act, he can join with another to bring about the execution of the accused. Because you might think that there is a halacha that says you cannot incriminate yourself with your own evidence. Okay, you can't incriminate yourself with your own evidence. You need to have two independent witnesses. You can't be a witness to your own crime. So you might think that he can't be a valid witness because he's agreeing that he consented to an illegal act, and therefore the whole testimony is kicked out because he is self-incriminating. Rav Yosef says that's not the case. He can be a witness against the sodomizer. And as it says here, he remains a valid witness, and one cannot render oneself wicked by his own testimony. He's not disqualified in any way on the basis of his own testimony, but only on the basis of the testimony of two valid witnesses. This is in accordance with Rava. Nevertheless, some say that one who testified to his own wickedness should not be allowed to bear witness, ab initio, in the first place. So, Rav Yosef says that if a man testifies that so-and-so sodomized him against his will, he and another witness may combine as a pair of witnesses to kill the defendant for the sin of homosexual sodomy. Lirtzono, but if someone who was sodomized testified that the accused sodomized with his consent, then, says Rav Yosef, he cannot testify because he is self-incriminating, and that is not the case. Not everybody agrees with Rav Yosef, as we've said. Rava disagrees, but Rav Yosef says he is not a valid witness because he's self-incriminating evidence. Rava says a person is his own relative. Okay, Rava Amar Adam Karov Etzel Atzmo, Ve'ein Adam Mesim Atzmo Rasha, and therefore a person cannot render himself wicked by his own testimony. Therefore, he, in that scenario, he is considered a valid witness to convict the sodomizer in combination with another. Okay, so again, two opinions here, and the principle that we're learning is whether, according to Rav Yosef, you can or can not incriminate yourself with your own testimony. According to Rav Yosef, you cannot, and therefore, if you say, yes, it was with my consent, your testimony is automatically kicked out. Rava says, no, that's not the case. A person cannot render himself wicked by his own testimony, and therefore he is deemed credible with regard to the sodomizer, but not with regard to himself. In other words, he can't incriminate himself, but he can incriminate the other person. I think we'll stop there because then the next little bit we're going to come onto is another principle which we need to go into in detail, and we won't have time to finish it. So let's just recap. We finished off the 8th case, which was a case of the Rabbi Yochanan ben Zakkai and the Rabbanan, of whether witnesses who contradict one another in non-vital evidence, let's put it that way, are considered to be disqualified. Rabbi Yochanan says they are, and therefore Rabbi Meir would go along with that, because he says it's never going to be a capital case, so only ever going to be a monetary case, and therefore 3 judges. The rabbis say no, that's not the case. If they are minor details that they disagree on, that does not disqualify their evidence, and therefore it could still be a capital case. And therefore they would go with the Chachamim, who say we need 23 judges in the first place. That was the 8th case. We went through all 8 cases. We eventually got there with the help of Art Scroll. And then we spoke about the important principle of Kam Le Mid'Rabba Mineh. The person only receives the greater of the 2 punishments. And we also clarified that and qualified it, that only occurs when we're talking about one case. When we're talking about against 2 different people, he may have to have both punishments because it's not 2 punishments for one case. And then finally, we had the opinion of Rabbi Yosef and Rava as to whether a person can himself join with another witness if the evidence that he gives is going to incriminate himself. According to Rabbi Yosef, he cannot. And the minute he says that, yes, I agreed to this act, even though it was illegal, he no longer becomes a valid witness. According to Rava, that's not the case. He can still join as a witness with somebody else to incriminate the perpetrator of the act, even though he consented and is therefore incriminating himself. Both Rava and Rav Yosef agree, however, that a person cannot incriminate himself. He can't be a witness against himself. So you can't. A
witness has got to be voluntary. So I can't see how the witness would actually say, "I'm a witness and I'm going to incriminate myself."
There are people that say, "Yeah, I did a terrible thing and I want to be punished for it.
Okay.
I want to do teshuvah, and the only way I can get kapara, the only way I can get forgiveness for this terrible sin that I did, is to admit my sin and take my punishment like a man."
Okay.
So in that scenario, he cannot, if there was only one witness to this event, and the other second witness is him himself, and he says, "Yes, I'm the witness, I did it, and I did it voluntarily," then he doesn't count. You can't incriminate yourself. He can, however, according to Rava, join with that other witness to incriminate the perpetrator. Rav Yosef says he can't. That's the machloket there. Okay?
He couldn't do teshuvah then if he can't do it himself.
He can't receive the punishment to do a complete teshuvah. I suppose he can do a teshuvah belev, but he can't gain kapara from having his punishment. He will get, if he does teshuvah belev, I guess Shamayim will work things out as it should be. But yeah, he can't achieve closure. That's true. Any questions on what we've done today?
Not a question, Johnny, but it's interesting that the American Constitution, the Fifth Amendment, is often brought into court hearings where you can't incriminate yourself. So it's obvious that the Americans derived this important rule from, which is mentioned in the notes to the Gemarah, that it came really from chapter 23 of Shemot, the first verse, and that's what they drew their ruling with the Fifth Amendment.
Yes, which isn't surprising, because of course the founding fathers were from Christians, weren't they?
Mm.
Very much of the American Constitution is based on the Judeo-Christian ethos and laws. So we shouldn't be surprised at that. And the American founding fathers based very much of their constitution and of their laws on the Bible, both what they would call the Old and the New Testament. So clearly the concept of the Fifth Amendment, I plead the Fifth. I've heard and read that many times in good crime novels. Plead the Fifth. That obviously is based on the Judeo-Christian law, and as you say, it's from the Torah itself. Very, very good observation. That. Thank you, Leon. Any other comments, questions? Okay, Kam le midoraba minei. Okay, if you don't remember anything else, Kam le midoraba minei. Okay, a very important principle. What's on this week? Now we're Wednesday. Okay, let me just stop the recording. Hang on, how do we do that? Stop recording. There we go.